March 13, 2024, 3 p.m. Calling Miss Tauber, Miriam Tauber.
After the tone, and Google Voice will try to connect you.
Ethan.
Hello?
Miriam.
Yes?
Good afternoon. How are you?
Good. Who's this?
Ethan. I'm an AMC shareholder.
Okay, how are you?
Good. I see that you settled in the Antara case.
Oh, well, we have an agreement in principle. Are you following the docket?
Yep, absolutely. I got a question.
The hearing is scheduled for April something or other.
May 2nd.
April 15th?
May 2nd.
Okay, yeah.
The deadline to submit an objection is April 16th, correct?
Okay, yeah, exactly. That's the order I'm talking about, yeah. So we don't have a settlement yet. We have to have the hearing and all other stuff, whatever.
Right. When are you guys supposed to brief your settlement?
Honestly, I'm not the attorney in charge of the briefing. That's my colleague James.
Mm-hmm.
So I'm not sure if he's actually submitted that or not. But if you are on the docket, you can tell. If it's not been submitted yet, then I think it's been submitted. I'm pretty sure there's a brief already on file in support of the settlement.
Did the district judge set a scheduling order? Meaning, what about notice to shareholders?
Yeah, so that's the order.
Yeah.
Right? The order is about providing notice. So then I think there was a clarification my colleague just submitted at the time, 1:15 at 1. And the court just clarified that, I think, yesterday. So I think the notice will be going out with the right time and everything.
And who's the who's administrating the postcard notice?
Honestly, my colleague James is the lead counsel on this. So do you have his number on the docket? You can call him.
Okay, then let me ask you this: who? I see that you've represented these plaintiffs multiple times.
The plaintiff?
Yeah, Mr. Rubenstein and Dennis Donahue, multiple times.
Okay, yeah. Yeah.
So I got a question.
The kind of cases I practice, the plaintiff is a nominal plaintiff. It's really on behalf of the company, right? So the company gets most of the recovery.
I totally understand the dynamics here. The question I have for you is this. Antara got a windfall of over $800 million. You understand they rigged the vote? Do you understand the dynamics of what happened with Project Popcorn? Hello? 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 March 13, 2024. She hung up on me. 302. Hello?
Sorry, my service cut out. I don't know. What's your last name, Ethan?
I got a question. Are you aware of Project Popcorn, the scheme?
I don't know anything to do with that. I know there's a lot of stuff going on with AMC, and we're not the only lawsuit.
I totally understand, but you're settling with Antara, a company
we're
that...
We're only settling one claim. We're settling a 16B claim.
But hold on.
Did you read the settlement agreement that was filed?
Miriam, can I have 1 minute, less than a minute to ask a question?
Yeah, but you keep asking me all these unrelated questions I don't know anything about, so I don't have... go ahead. Ask me anything you want.
Unrelated, you're now settling with a company that helped and aided and abetted AMC in a Project Popcorn scheme to rig a vote. You're now settling with us putative class members are fully aware of the scheme called Project Popcorn. Are you aware of the elements of the scheme?
We don't know anything about it, but if you read the settlement agreement, what I'm trying to tell you is it's very limited. We're not settling all claims against Antara.
I don't care. I don't even care. Miriam.
Another claim involving a different thing that it's not covered by our agreement.
Miriam,
Right?
I'm going to ask you this. Miriam, hold on. Miriam, you're now releasing them of a claim that other people...
You don't understand what I'm saying.
Yes, I totally understand.
What we're releasing them of is only one claim.
Why release them anyway? Miriam, why are you releasing for a settlement of $3.2 million?
Do you know what our claim is?
Of course I do.
Okay, so what's our claim?
Oh, you're asking me. That they traded short-term gains, and they're not allowed to. In violation.
Purchases and sales, right?
Right, now here's the question I have you. Why were they allowed to...
We're not releasing other claims. We're not letting them off the hook for anything else.
Miriam,
right?
Miriam, את מבינה עברית? Miriam, את מבינה עברית? Do you speak Hebrew? Miriam, do you speak Hebrew?
I do, actually.
יפה, בוא נדבר עברית, זה נראה לי שאת לא מבינה ש...
I'm not like fluent in Hebrew. I mean, I understand it fluently. I'm American, I'm not Israeli.
Miriam, here's the problem that us putative class members are going to expose you guys.
Yeah.
We're going to ambush.
What are you talking about?
Then listen, Miriam, how about this? You got the floor for whatever you want, and then allow me to speak. Let's do it. Go ahead. You got the flashlight right now. When the flashlight's in your hand, go ahead. You got the floor.
No, I don't even have to answer your phone call. Do you understand that? You're welcome to come to the hearing.
Ma'am, you're representing the class. You're representing the class, correct?
No, we're representing the company, AMC. It's a derivative.
You're not representing the company. They're a nominal defendant.
We're not. This is not a class action, okay? So this is a different kind of case. It's a derivative case.
Correct. You're suing, your client is suing a nominal defendant, AMC, and the defendants are Antara. Now, here's the problem I have with you. You are now settling with a company that you don't even know why there's short-term windfall. I mean, when they flipped it.
That's why we have to settle, okay? AMC is probably going to declare bankruptcy, right? And if they declare bankruptcy, then everybody gets nothing.
Miriam, do you understand the scheme? I'm going to ask you one last time, because I'm now going to tell the district judge, that you and I had a colloquy, and you have no clue what Project Popcorn is.
Great. Okay. Now, tell us anything you want.
How much money are you asking from the settlement?
I told you that my colleague James Hunter is in charge of this case, so I really want you to direct all questions to him. Have you spoken to him?
No, you're the first person I was going to speak to. Mr. Lopez?
No, James Hunter.
There's only two notice of appearances, one from Lopez and one from you.
No. Do you see James Hunter on there?
Hold on, parties. Represented by... You got David Lopez, Miriam Tauber, and
then James Hunter. Do you see him on there?
Nope.
Okay. Well, I don't know if I'm looking at the right docket then, because
trust me, it's the right docket, sweetie.
Okay. Well,
docket entry is 23 Civ 04985.
I honestly, so I'm a ancillary co-counsel on this case, and I have an agreement with my counsel that he is the main counsel, and on this particular matter, I am deferring to my lead counsel on this, who is taking care of this matter. I really am very tangentially involved in this case. If it was any other case, I'd be happy to discuss the details with you. But this case, I'm taking a very passive role in it because my colleague James Hunter is the lead counsel.
All right, then let me ask you one last question, and then we could part our ways.
Okay.
Excuse me?
Yeah, go ahead.
I've laid the foundation that I noticed that you guys have represented Mr. Rubenstein and Mr. Donahue multiple times.
Sure.
Are you guys hired by the defendants to procure settlements and releases?
I don't know what you're talking about. Every case is different, okay?
Then I'll explain it again. Miriam, I'm going to ask you this again because you're not aware of what happened in Delaware. And I've told you...
I'm only very, moderately aware, but I knew there's a case in Delaware. I don't know what happened.
Then Miriam, I'll lay it... I told you, let me have the flashlight for a second. You had it before.
Okay,
in Delaware...
Still to me, and I don't understand why... I don't need to entertain your phone call just to be, yelled at and badgered.
Yelled at?
Right?
I'm asking
I've seen on the internet, there's a lot of, negative things written about me and David Lopez, about my clients, everything else. I don't think you guys fully understand what's going on here. Not in this case, but like our practice and everything else. And that's fine. I'm not going to respond to every allegation you guys get on the internet. But obviously, you guys are not lawyers.
Miriam. I'll ask you a very simple question. Why did the stock AMC go down from $45 down to 44 cents? If you can't answer that question, that means you're not fully versed on the action.
You tell me why.
How about this one? I'll do one better. I've put together a statement of facts that us shareholders are going to use when we file suit.
Okay.
And the statement of facts is 258 pages. It outlines, because we got discovery in Delaware, and both party attorneys out in Delaware opposed our motion. Our putative class members filed motions.
Okay.
Judge Zern in Delaware granted that motion, and we got discovery. And this is how we're privy to the scheme of the century called Project Popcorn. Now, I'll tell you, I don't want to bore you with all the elements, but listen to this very carefully. Project Popcorn in its genesis was conceived on January 27, 2021. It was memorialized on approximately November 3rd, 2021. Insiders front-ran Project Popcorn. What is Project Popcorn? Citibank and all these bad actors were naked short AMC. They needed shares. All of us shareholders did not want any more dilution. We wanted to donate $1,000 to eradicate the debt. Adam Aaron could not have it. Why? Because this is the scheme of the century. Long story short, Project Popcorn pivoted from a rights offering to an ATM, which is an outright dilution. You don't have to take my word. So what happens? They then move forward in ATM. May 17th, D.F. King with AMC, Citigroup, come up with a game plan, which is do the conversion reverse split. On May 25th, Riley Financial May 27th, reaches out to John Merriweather and Sean Goodman about the scheme that was implemented on 3 stocks, AVGR, AGRX, and OPGN, on NASDAQ. The problem is AMC's on New York. This scheme was using preferred reverse split conversion. All those 3 stocks got smoked subsequent to them being moved forward. NASDAQ and New York Stock Exchange are 2 different exchanges, 2 different standards. So they set precedents. This is all in emails. So they knew once they moved forward with preferred shares and conversion reverse split, it was going to smoke the stock. And that was their intent, because they needed the stock to go down.
Okay.
Do you understand? Now, how does Antara get involved? In order to rig the vote, they needed a hedge fund. So here's what happens. They move forward with Project Popcorn. They launch Ape. Ape tanks, and they knew it was going to take down. Why? Because institutions cannot hold preferred stock. That's not in their index. So 78 million shares were sold off from day one. The board committee set the price to sell Ape at the lowest. The floor was $2. It breaks 2, they lower the floor to 1. Now, why did they need that? Because back in May, Weinberg, who works at D.F. King, explained to him how to rig the vote. In order for this to be successful, they didn't want Ape to trade. The intent was to convert Ape into AMC. And you could see it 3 months before Ape is even launched. They're talking, how is Ape and moving forward with this going to be successful? They needed the conversion. So now they have to rig the vote. They had data. If this happens, this is how we get it. So mind you, in order to get the most bang for your buck to vote, you got to get the price down. So now AMC and Ape are trading with never traded at parity. Mm-hmm. They take it down. They tank it. Adam Aaron does not support the stock. Instead, he's asking, let's set the floor even lower. It finally breaks $1. It gets to 68 cents. That is when emails come on December 6th. D.F. King, Crystal Scordato reaches out to AMC. gives them a dynamic ledger from Excel sheet that explains to them how many shares they need in order to rig the vote. Enters Antara. Then there's an email on December 7th, a meeting. December 8th is an email. Antara is willing to hold shares to rig the vote and vote this way. They have 190 million shares to invest, quote unquote invest, which gives them 278 million shares. That is enough shares to rig the vote. They promised to hold it. Now, why did they get away with the selling short term? Because part of the quid pro quo was Adam Aaron agreed to allow them to sell shares once it breached 3. Do you understand? How about this? Let me send you the statement of facts.
That's great, but listen, it sounds like you have a great case, okay? There's a lot of...
A case? I'm not looking for a case. I'm not looking to settle with Antara, who are the criminals.
Listen, okay. Listen to me, all right?
Yeah.
I have sued lots of companies, all right? So I've sued, let's say, like, you ever heard of Martin Shkreli? Remember him, right? I sued his company, right? At the same time, the SEC was also suing his company. At the same time, the DOJ was pursuing criminal case charges against him, right? At the same time, other stuff was going on, right? I settled my case against him, okay? It didn't affect any of that stuff. It was a shareholder suit at the same time, a class action, right? For other stuff, for 10b5 stuff, which is regular fraud.
Well, let me ask you this. Why don't you ask...
You talked for a while now.
Go ahead. You got the floor. Go ahead.
My claim does not involve fraud, okay? We're not suing them for fraud. We're suing them for a straightforward statutory violation. It doesn't require there to be any malicious intent. And in fact, in many of my cases, the person who violated this rule against short swing trading didn't do any fraud, okay, at all.
Then I'll ask you, Miriam, why were there short-term selling? Why was there short-term selling?
Just listen to me.
No, Miriam, you don't even know. Hold on, Miriam. All right, you know what? You got the floor. I'll ask you a question after. Go ahead. Sorry. You're right. Go ahead.
When I settle my case for the statutory violation, right, because it is not a fraud case, it doesn't affect any claims that have to do with any kind of fraudulent activity, which just sounds like what you're describing, right, in much more detail than I need to know, quite frankly. Okay? So, you sound like you have a great case, and you should definitely pursue it. And it will not be affected by the settlement of this claim at all. Do you understand that?
Miriam, I'll ask you this again. Why was there short-term selling?
Okay, do you know what short
swing selling. Why was there short-term selling?
Trading means that you're buying and selling.
Why was there?
Right? Okay, it doesn't, for purposes of my claim, okay, what I'm trying to tell you, it doesn't matter. The statute, if you look at the statute that I'm suing under, it sounds like you're familiar with the complaint and everything else. If you look at the statute that I'm suing under, which you can Google, the statute specifically says it applies without any, irrespective of any intent on the part of the insider, which means that it doesn't matter that the insider is acting in good faith, bad faith, defrauded anybody, or didn't, right? It could be that the insider was completely unaware of the rule, just tried to pay off the debt, had needed money for his kids' camp. It doesn't matter, right? It doesn't matter why they did it. If they still need to give back the profits, right? And profits are calculated under specific rules, and that's how it is. It's a statutory claim for strict liability, and it does not, settling this claim does not mean that they are off the hook for fraudulent conduct, which is a separate claim. Okay, so that's under 10b5, a separate section of the Securities Exchange Act. And it doesn't, for example, the Delaware case is going on, right? It doesn't mean that we can't pursue this claim because the Delaware case is a class action, which it sounds like your case also is. Okay, this is not a class action. This is not a derivative claim.
Right.
That's a statutory strict liability case. It's very specific. It doesn't affect anything else. So I don't think that you should be mad at me for settling something that you think is affecting anything else that you are talking about. I don't have to know any of that. It's none of my business. I mean, if I was hired to pursue the case, then it would be. But I don't care. This is a strict liability case. I don't care what the intent was. You want to bring that case? Go for it. No one is stopping you. The settlement certainly will not stop you. Okay?
How much discovery did you conduct, if you don't mind me asking?
we didn't conduct any discovery because discovery is not needed since they filed the SEC Form 4s that admitted that they engaged in this trading. And this trading is a per se violation of the rule against short swing trading. Profits are calculated in a very specific way.
I'll ask you this again.
Okay.
Why didn't you? Then how come you didn't entertain discovery?
Because there's no need for discovery as they admit to the trading they did.
I'm going to ask again. Why didn't you conduct further discovery? You're trying to help the company out. Why don't you conduct other discovery?
Okay. All right. So, I honestly, I can't debate this with you all day. We don't. I have. You're not my client, okay? And I don't even have to take this phone call. Okay? Come to the hearing and state your grievances. All right, and we'll have this debate before the judge.
All right, then I'll ask that last question, and we'll come back full circle. Why did Antara sell shares short term anyway?
I tell you again, I don't care why, because my statute applies.
I'm just asking you. Don't you want to know?
Sure. No, I don't give a shit, but you can tell me. Sure. Why?
All right, so here we go. Back in December 8th, there's an email exchange between Citigroup, Derek Van Zandt, and AMC. It says the terms. They're willing to buy X amount of shares, which was 190 million they're putting up at 60-something cents, which came out to 278 million shares. Antara wanted all control. One of the stipulations that they agreed to is, now mind you, APE was trading at 68 cents. They get a windfall now, 278 million shares. This is quid pro quo. They're now going to use all their shares to vote yes. That's part of the agreement. They're rigging the vote. As I told you, on December 6th, there's an email exchange with D.F. King explaining to AMC with a dynamic Excel sheet ledger, if you manipulate the numbers, how do we guarantee to get the vote to move forward to convert? Because that's what their intent was. It was never to allow APE to randomly continue to trade with AMC forever. So here's the point. Part of the conditions, not only to vote yes on all the three proposals, was this. Ready for it? Once APE breached $3, and that happened, I'll tell you when. Hold on. It was February 2nd, because the record date was February 8th. February 2nd, it breached 3 for the first time, which now allowed Antara to continue to sell and collect on their windfall. Why did they need this? Because this is part of the scheme. They couldn't allow the stock to keep rising. Do you understand? And now you're entertaining a corrupt entity, hedge fund, that has screwed us shareholders. Do you understand, Miriam?
No. Like I told you, I'm getting money out of them, right?
$3 million. Who cares about 3?
Get money out of them if you want. It doesn't really.
Miriam Takshivi, do you understand that the market cap of AMC went from 23.7 billion down to 780 million in market cap because of Project Popcorn?
Nothing is relevant. None of this is relevant to my claim. You are free to pursue any other claims you want, and the release does not release anything you're talking about, even if they relate to these transactions. Okay?
So I just gave you notice that fraud's being committed against us shareholders, and you don't care.
I told you again, this is not a fraud case.
I'm giving you now notice as a shareholder to an attorney. You're now mandated. Ethical obligation is to give the judge notice. Well, you know what, Miriam? Well, hold on, one last thing. Miriam, one last thing. I have you on a recorded line, and I'm going to give this to the judge. Be good.